the assurances deal with all the problems. I'll deal with that. And I will also deal with monitoring and non-return, since they feature prominently in the Lord Chief Justice's dissent. I'll focus on those. I'm going to deal with everything that's in his case. But I'm focusing on the big points: approach to assurances, relevance of past, UNHCR expertise, ex facie, monitoring, non-return, plus the other issues that are raised in this case. Just to frame my submissions, a word on the Lord Chief Justice's dissent, if I may, or a few words. It's inappropriate for my learned friend simply to point to the dissent, because the Lord Chief Justice did not identify any basis on which the Court of Appeal majority was wrong. It's disagreement territory. He proceeded to reconsider the facts with great respect, even though he had found that the Divisional Court had given itself a correct self-direction. We see that at 493. But he accepted, perhaps most fundamentally, that you cannot elide good faith with capacity to deliver. It's no good Sir James saying, in this case you can't. As far as he was concerned, the Lord Chief was concerned, he said you couldn't in this case. And perhaps even more importantly, the Lord Chief Justice said that the government has no special expertise on that the latter question, 471. He did not regard capacity as merely turning on numbers. He saw it, like Lord Justice Underhill and the Master Rolls, as qualitative as well as quantitative. See 466 to 467. Lord Justice Underhill is at 261 on this point, Master Rolls at 95 and 104. He accepted that the past and present were relevant, 470. He accepted there were, quote unquote, undoubted deficiencies in the asylum system, paragraph 471. He expressed gratitude for Lord Justice Underhill's comprehensive review, which informs this issue, quote unquote, at 493, which was, of course, based on UNHCR's evidence and was not carried out by the Divisional Court. He accepted, quote unquote, that the UNHCR had unrivaled practical experience, 467. He accepted UNHCR's account of refoulement, their table of 100 cases, as troubling, quote unquote, paragraph 500. And paragraph 502, he shared the concerns of UNHCR about whether those involved in the RSDC have sufficient training and expertise to deal appropriately with asylum claims, and also whether what are reported as ingrained attitudes of skepticism towards claims made by Middle Eastern nationals will be influential. There is certainly evidence of poor practice. That's 502. That's the dissentient. He disagreed with the majority. I emphasize, not identifying any basis on which they were wrong. I'm using wrong throughout my submissions in the technical sense. He disagreed essentially as to the weight that the majority placed on monitoring and incentives for compliance, 511, and that their view, secondly, and their view of risk of refoulement in the light of the plus refoulement issue, as Sir James put it, 499 to 501. So in our submission, it is very clear that the Secretary of State has to travel further, and does travel further than the Lord Chief Justice. With great respect to him, we say, having accepted everything he did, his answers first don't demonstrate that the majority were wrong, but really don't justify the conclusion that he came to. The Secretary of State's tack is not to endorse him, but to go much further. And that shows, we say, the ambition of Sir James's case. On the major issues, elision between good faith ability to deliver, relevance of past UNHCR expertise, the Lord Chief was with the majority. So the first main issue, the court's approach to assurances. This is our case at 54, Sir James at 81. He says that it's wrong when assessing the reliability of assurances to distinguish between the question of whether a government intends to abide by assurances and whether it's able to do so. First point, the questions are obviously distinct. They were treated as distinct, for example, in Ottman. At page 7522, you have the court quoting from Mr. referring to Mr. Layden and saying there was sufficient evidence for it to conclude that the assurances were given in good faith, and that was one of the factors, quote unquote, that made strict compliance with both the letter and the spirit of the MOU more likely. All three judges saw a distinction. I've already referred to the Lord Chief Justice at 471. He referred to the need to look at the capacity of the system to deliver. I've already said he correctly regarded UNHCR's capacity concern as not simply turning on numbers, 466, 467. Lord Justice Underhill at 270 accepted that great weight should be given to the government's good faith willingness assessment, but the real issue is not the good faith of the government of Rwanda at the political level, but its ability to deliver in light of the present state of the Rwandan asylum system. That's 270. 261, aspiration and reality don't necessarily coincide. Not an answer to say Rwanda can decline to accept more RIs, relocated individuals, than the process can cope with. And similarly, the Master Rolls at 84, not an answer to say good faith. Question is, in light of events on the ground, would the assurances be complied with? And 91, the likelihood of promises being performed must in part be judged by reference to what has happened in the past and the capacity and capability of the entity making the promises to keep them. So James says at 77 to 78 in his case that the assessment of both issues, good faith and deliverability, attracts equal and great respect on grounds of expertise and constitutional grounds. I want to first address, if I may, the expertise issue. The idea is, as he puts it, that the courts aren't institutionally well equipped to make such an assessment. I'll come on to the political judicial judgment in a moment. Again, this is inconsistent with everyone below. At 470, the Lord Chief Justice said that that good faith and intention to deliver issues fall squarely within an assessment of the value of these assurances. Capacity issues are perhaps hybrid, falling within diplomatic assessment, and more straightforward issues of fact There are questions about whether the will of the government of Rwanda will be effective in dictating the approach and conducts of official down the line. And then this, the worth of diplomatic assurance calls for an exercise of judgment in which the government has expertise and access to advice, which a court doesn't. Court isn't institutionally well equipped to make such a judgment. We don't contest that. But, and this is the heart of the case, and this is the dissentient, but where the assessment of future conduct engages practical considerations which arise from past conduct, the position isn't a start. In this case, there is very detailed evidence of the way in which the Rwandan system has operated when considering individual claims before the summer of July 22. There were undoubted deficiencies. And then this sentence, whether they're capable of being made good is not an issue on which the government has special institutional expertise. Now, that last sentence, we say, is obviously right, both at the level of principle and on the evidence. Firstly, at the level of principle, if you're going to ask yourself the question, are the assurances deliverable, you've got to have knowledge of the system and matters on the ground and what is required to remedy such problems as there are and how long it's going to take. The government had no significant expertise, and that's putting it very generously. In fact, they had no expertise at all on this issue or access to expert, impartial, objective advice other than through UNHCR. And I'll deal with UNHCR's expertise in a moment, but they said as much. So this is my Lord Briggs' question. Who comes out on top? Well, the government is saying that it's the UNHCR that have got the expertise, and the references are that they were referred to in the Master of the Rolls at 94, but if I just give you some page references, there was a note from Christian Langford. You don't see that it's from him, but there's a note which is at 3092 to 3096.
And who's the author of the note?
It's somebody called Christian Langford, and it was exhibited, I think, to Mr. Armstrong's statement.
And who's Mr. Langford?
I think he was one of the officials who was negotiating with the Rwandan government.
Yep.
So, can you just check? But I'm sorry, if I'm wrong, I'm pretty sure I'm right. If I'm wrong, I'll correct myself. But he says that at paragraph 2 on 3092, it was clear that country X depend heavily on the UNHCR and other NGOs for delivering the domestic asylum and refugee processes. And then at the bottom of the page, he says, however, it's in the same paragraph, however, due to sensitivities, there was no clearance to speak to them. This was referring to the first visit of 17th of 21st of January. And then at paragraph 3, we also currently have no independent verification of what we have been told by Rwanda. And then at paragraph 3096, you've got Annex A, and on the right hand of the grid, why we want to talk to the UNHCR, you have this. They have undoubted expertise and experience of managing part of the refugee process, as well as knowledge of the system more generally. Then the next item in your bundle is an email from the 8th of March. We don't know who it's from, but it's to Sir Matthew Rycroft. And we see there that the references to ministerial clearance is required for speaking to the UNHCR and other NGOs as part of a second fact-finding mission.
And Mr. Rycroft at the time would be the permanent secretary?
Yes. And then this is a critical part of assessing whether country X is a safe third country. So the expertise is accepted of the UNHCR. In terms that we also currently have no independent verification of what we've been told. UNHCR undoubtedly have expertise of the system more generally, and knowledge of the system more generally. And I'll come back to how it is said that the government suddenly acquired expertise, but a month later. You look at the timeline, this is March. The MEDP is signed on the 13th of April. In a month, it is said, in an answer to my Lord Briggs, Sir James says, negotiation. So a month. That's how they get the expertise. UNHCR have been there for 30 years. The Secretary of State's evidence does not suggest that there was any expertise. Mr. Mustard, at paragraph 20, from the FCDO, says, and I'll just give you the reference if I may, page 2747, that in light of the considerations described in this witness statement and the manner in which negotiations with our Rwandan counterparts were conducted, we are confident that Rwanda will honour its commitments. That says, with great respect, nothing about deliverability in light of the systems on the ground, and it notably comes from an FCDO official whose focus would be good faith, history of bilateral relations, as opposed to a Home Office official focusing on questions of capacity. And he even says at paragraph 2 that he's prepared the statement at a fairly high level, that's my phrase, based upon discussions with FDCO colleagues and remote working software. So we respectfully submit that there was no access to expert, impartial, objective advice as to deliverability. All the Secretary of State had was responses exhibited to Mr. Armstrong's statement and not assessed to UNHCR material and Home Office questions based upon that material. And in Lord Justice Underhill's words at 137, those responses weren't very satisfactory. It's not stated from which departments or other sources the statements in them are derived, and they are at several points unclear, lacking in detail, or inconsistent. So the Secretary of State does not bring her own expertise to bear, does not bring her own advice to bear, or advice from independent, reliable, objective sources. She is completely reliant on Rwandan responses to Mr. Botnick's second statement. The next point, my lords, is that at the level of principle, this is unsurprising. And the reason it's unsurprising is that at the level of principle, His Majesty's government do not have significant institutional expertise in devising or correcting seriously defective asylum processes. It's not what we do. There's no evidence to that effect. Home Office officials didn't, for example, look at wholesale failures in the German system, in Yogathos, or the Italian system in EM Eritrea, and think about how it could be corrected. The Dublin context is obviously completely different. Mutual trust and confidence, etc. So this appears, as the UNHCR say, to be an unprecedented situation. Their observations, paragraph 34, page 434.
Even in the Dublin context, weren't transfers to Greece suspended for several years?
Absolutely, my lord. That's the MSS case upon which my learned friends rely. Yes, they were. But my point is that it wasn't. There was no part of when the challenge came in the UK. There was no part of the Home Office's task to go to Greece and work out how they could devise a proper system. The most that we get is Mr. Armstrong, he's head of the Third Country Asylum Partnership Task Force, but he does not say that he has experience of RSD reform. And then Sir James's answer to my Lord Briggs, the idea that expertise was acquired through negotiation in some months in 2022. That's the divisional court at 71. Firstly, I've already made the temporal point. And the second point is this isn't experience or expertise of how the Rwandan asylum system works on the ground, or how it could be improved. And what you have, as again I've said, is uncritical acceptance. Lord Justice Underhill, paragraph 268, he described the Home Office's uncritical, too ready to accept Rwandan responses. And there was another problem, that with respect to a number of the criticisms, the problems simply weren't acknowledged. In order to correct a defect, you've got to acknowledge that it exists. Lord Justice Underhill, on the example of deficient interviews, said in terms at 169, the Rwandans don't accept there's a problem, and that is a problem. Can it be said, as Sir James says, that the court isn't institutionally well equipped to make a judgment on deliverability? He says that at paragraphs 77, 78 of his case. We say that it is a fundamental part of the court's task to scrutinise legal processes and their compliance with human rights standards. That is what courts do. Parliament requires that through Section 6. And domestic courts at all levels, of course, are very well used to carrying out that exercise, both in relation to the UK's asylum system and foreign asylum systems in the context of the sorts of cases that I was just mentioning. It's not suggested by Sir James that the courts in this case did not have relevant material provided to them. We say they didn't because the Secretary of State refused to disclose the funding note verbal. So that's where you've got an insufficiency of evidence. Sir James hasn't said that you've not had enough evidence. And in fact, as I said yesterday, the court has more material to consider than the Secretary of State because of Mr. Botnick's third statement, to which there was no substantive response. And then your lordships have the point about special responsibility. Bugdaikai, page 4251, the need anxiously and rigorously to scrutinise foreseeable consequences of removal. EM Eritrea, Lord Kerr, at page 5608, and Lord Justice Simon Brown in Turgot, pages 4477 to 4478. This is not an area in which the court will pay any special deference to the Secretary's conclusion on the facts. In the first place, the human right involved here is both absolute and fundamental. Secondly, the court here is hardly less well placed than the Secretary of State himself to evaluate the risk once the relevant material is placed before it. That was in a judicial review context. It's a fortiori now. It was a pre-Human Rights Act case. And the last thing that we make, the last point we want to say about expertise is that it would be very surprising if a non-binding, non-justiciable, bilateral assurance transformed the judicial approach to scrutinising compliance with domesticated, binding treaty obligations, a fortiori in circumstances where the very point of that non-binding assurance is designed to secure that compliance. This is a point that Sir James made lots of times. It's a point against him. The whole point of this is to get compliance with the Refugee Convention. That's what the courts do, assess foreign systems for Refugee Convention compliance. I'll come on to Zabolotny, Belhaj in a minute. It would be totally appropriate on the basis of a non-binding, non-justiciable, bilateral assurance for the Secretary of State to be handed a blank cheque on deliverability, which is, with respect, what Sir James's submission amounts to. So those are my submissions on expertise. The next submission I want to make...
Just before you do, you just mentioned the Refugee Convention.
Sorry, it's Article 3.
Yes, quite.
Sorry.
And it just occurs to me it's perhaps worth just raising this point with you. The claimant's case is based on the Human Rights Act, which
yes.
gives effect, of course, to the Human Rights Convention. But non-refoulement is a much wider core principle of international law, and it's also given effect, isn't it, in the Refugee Convention, and indeed the Torture Convention. And both of those are also given effect by Parliament in our domestic law.
My Lord, yes. Absolutely.
Yeah. We needn't pursue the point, just to...
Yeah, these are domesticated binding treaty obligations. There's an interesting academic debate about whether they also form customary international law. The Swiss Federal Office has said they do. Recently, they even said it's just cogents.
Yes.
But yes, absolutely domesticated. The next point I wanted to make is that the Secretary claims at 76 to 79 of her case that her views on deliverability command respect on both constitutional grounds and because her assessment involves prediction. I'll just deal with prediction very quickly, if I may. She relies on Raymond. 5 quick points. Our case 54, paragraph 54. Raymond Lord Slynn said that in that context, deportation in the interest of national security meant that the Secretary of State had to have regard to quote unquote, sorry, I don't think we quote this in our case. The page in Raymond is 4594. It's paragraph 22, letter B, page 5494. Lord Slynn said in the context of Raymond...
5494 or 4594? You gave...
4595, sorry.
Thank you.
Sorry, apologies. So this is the first of my 5 quick points, if I may, on prediction and Raymond. Lord Slynn saying in terms that the Secretary of State was entitled, quote unquote, to have regard to precautionary and preventative principles rather than to wait until directly harmful activities have taken place. That's what he says in Raymond. Second point, of course, those precautionary and preventative principles operate in our favour, not the Secretary of State's, because the Secretary of State's duty is to avert or prevent Article 3 risks, just as, or not to set in train, or not to subject individuals to Article 3 ill treatment, just as it was in Raymond to avert and prevent risks to national security. Every Syrian case is predictive and preventative. Third point, very quick reference to Lord Bingham in this is the second Belmarsh case, at pages 4872 to 3, where he quotes with approval a long passage from the ICTY, International Criminal Tribunal for former Yugoslavia, in the case of Furundisia. And it's an important passage. He says, states are obliged not only to prohibit and punish torture, but also to forestall its occurrence. It is insufficient, merely to intervene after the infliction of torture when the physical and moral integrity of human beings has already been irremediably damaged, as was authoritatively held in Suring. International law intends to bar not only actual breaches, but also potential breaches of the prohibition against torture, as well as inhuman and degrading treatment. High authority for the preventative principle applying in our favour, not to the Secretary of State's when you are in Article 3 territory. Fourth point, that is why an effective remedy for Article 3 purposes must be suspensive. Just one reference, if I may, the MSS and Greece case at page 7347, paragraph 293, the Grand Chamber saying it's got to have suspensive effect.
You're going rather fast with respect, and I'm not recording all your references.
No.
What was the reference you've just given?
To MSS in Greece. I'm sorry, it's 7347. I'm so sorry if I'm going too fast.
So you're saying effective remedy
must be suspensive.
And you gave us a paragraph reference. Which paragraph?
293. And what they say is, in view of the importance the court attaches to Article 3 and the irreversible nature of the damage, they mean normatively irreversible, nobody has a time machine, irreversible nature of the damage which may result if the risk of torture or ill treatment materializes, effective remedy must have suspensive effect, skipping some words. So the preventative paradigm is absolutely in play. Not enough to have a post hoc remedy. Even in the context of detention, you have false imprisonment. Habeas is the better remedy, but false imprisonment is contemplated as a remedy after the effect. Here, the preventative paradigm is the governing paradigm. And it's the fifth short point I wanted to make is why the somewhat pejorative reference, both in Sir James's case and his submissions, to the idea that we have launched a quote-unquote preemptive challenge is wholly misplaced. What are we supposed to do? Wait until a client is refooled to be told, well, your case is an academic. So those are my 5 points on why his submissions involve a reversal of precautionary and preventative principles. I want to make 4 short points on the issue of constitutional grounds for deference. First point, Lord Hoffman in Raymond, our case at 49, and it's page 4603 of your bundle, Raymond at paragraph 54. Lord Hoffman, quote unquote, the executive enjoys no constitutional prerogative on the Article 3 question. And that's because there's no public interest in play. As the plenary court held in Chahal, as the Grand Chamber confirmed about 13 years later in Sadi, in case my Lord Sales may recall. No public interest in play. It's an absolute non-derogable right. The executive enjoys no constitutional prerogative. And the contrast is with, in that case, national security, where he said at paragraph 62 in his postscript, page 4605, what's in the interest of national security? Such decisions with potential results for the community require legitimacy which can be conferred only by entrusting them to persons responsible to the community through democratic processes. And your Lordship, the President, discussed those passages in Begum at pages 6603 to 6606, paragraphs 51 to 62. The second point I wanted to make, sorry if I went too fast. The second point I wanted to make is derives from the observations of my Lord Lloyd Jones in Zabolotny, our case 52. So this was in the context of an EAW extradition request, mutual trust, fully in play, and in the context of an assurance given to a third state. And what my Lord said at paragraph 45, page 6644, was, quote unquote, "There is no room here for the operation of any exclusionary rule which would prohibit the court from ruling on the reliability of an assurance given by a foreign state." And your Lordship referred to Rahmatullah and Belhaj, Lord Sumption, effectively saying that foreign state immunity doesn't arise where you've got, and courts look at institutions in the context of deportation and removal and examine assurances. That's 45 in Zabolotny. The third point I wanted to make is that my learned friend's submission is patently inconsistent with what is called an obligation in Ottman. And this is our case at paragraph 51. It's patently inconsistent with the obligation in Ottman to examine whether assurances provide, in their practical application, a sufficient guarantee. That's para 187, the paragraph Sir James accommodated me on yesterday. Para 187 from Ottman, page 7519. Thank you, Mr. Wardell. 7519. And the court there said that assurances constitute, quote unquote, a further relevant factor. So they're not dispositive. They're part of the assessment. They don't transform the assessment. It said assurances are not in themselves sufficient to ensure adequate protection. I'll come back to that when I look at the ex facie submission. Your Lordships will immediately see how inconsistent that is with the idea that you look ex facie coverage. And there are previous cases as well, previous and subsequent cases where there is a focus on that obligation. Just one reference, Sadi Grand Chamber, para 148, again referring to an obligation, page 7276.
7276.
7276. And so the last point, to summarise, the presence of assurances doesn't magically alter the required approach. According to Sir James, the field narrows to the Home Secretary alone. The court is excluded. So is the UNHCR. Notwithstanding the Human Rights Act, her case is that the assessment of Rwanda's capacity to comply with the assurances is effectively final. If that's right, then SIAC has been in error since its inception in 1997. Lord Hoffman was wrong in Raymond. My Lord the President was wrong in Begum. It would mean that my Lord Jones was wrong in Zabolotny, unanimous Supreme Court. It would mean that Ottman is constitutionally unacceptable at the domestic level, despite it being repeatedly accepted and implied, and it would ultimately mean that the court would be abdicating its responsibility given by Parliament under Section 6 of the Human Rights Act in favour of a policy, an agreement, and an assessment of the executive alone, with no parliamentary imprimatur. The Secretary of State's case admits and confronts none of this. Sir James, with respect to him, seeks to skate past the implications of this quite extravagant and heretical submission. And as a postscript, I just want to refer at our case 58 to the very, very considerable respect that the majority afforded to the MEDP. We've got a long footnote, apologies for the length and the density of that footnote, where at multiple junctures, I counted 11 examples where Lord Justice Underhill modified his view of the Rwandan system in light of the MEDP. And of course, your lordships have the point that both the master rolls at paragraphs 96 and 97 and Lord Justice Underhill at paragraph 155 and 156, they both accepted that the MEDP means there isn't going to be an airport pushback, but that didn't mean that that very quote-unquote troubling evidence, that's the Lord Chief, troubling evidence was irrelevant because it showed either a misunderstanding of non-refoulement or a deliberate disregard, that was the phrase, of Refugee Convention obligations, together with decision-making based on bias and external relations. Well, in Friend's case, is this arbitrary decision-making should somehow, we should just assume it's not going to apply because of the MEDP. It doesn't properly engage with the gravamen of those examples. I'm sorry, I'm getting ahead of myself. The point I was trying to make was that the majority gave very considerable respect, not just good faith, very considerable respect to the MEDP, where they thought the assurances were deliverable, they adjusted for them. The second point, the second head I want to address with you, again, I'm going to, if I may, I'll do it very quickly, is UNHCR expertise. And three very short points. Our case 39 and 54. First point, all three judges and now the Secretary of State rightly accept UNHCR expertise. Sir James says UNHCR's views about the past are entitled to respect and consideration in light of its practical experience. It's not just the past, it's still the present. The cut-off at July 22, I'll come on in a minute to the importance of my Lord Jones's observation right at the beginning of the hearing about no parallel system. I'll come on to that in a minute. But it's not just the past, but also the present. The master rolls at 13 Roman 3, paragraphs 85 to 87, 92, 94, Lord Justice Underhill 136, the Lord Chief at 467, unrivaled practical experience, and the other references I gave you. Second point, Sir James says that UNHCR is neither expert nor experienced in relation to these new bespoke arrangements under the MEDP or in making the sort of predictive judgments made here by the government. Our answer, the MEDP concerns the Rwandan refugee system, asylum system, and it seeks to ensure Rwanda's compliance with the Refugee Convention. Those questions are refugee status determination systems, Refugee Convention compliance, obviously are at the heart, as the UNHCR put it, the heart of its mandate and expertise. See paragraph 2.1 of my learned friend's observations. Heart of their mandate, observations in the Supreme Court, paragraph 2.1, and in the Court of Appeal at 16.2, it's put at slightly greater length there, pages 2197 to 98. 2197, 2198. And moreover, I'm sure they'll develop this, as they say in their observations of this court, that they do have experience of MOUs. Their observations 5.3. And then the last point I wanted to make, just on this, is that the Secretary of State is wrong to suggest, as she does at 88.2, that there's no constitutional basis for affording any particular degree of respect to the UNHCR's view. That is, with respect, an own goal to raise that issue, because there's no constitutional basis to respect the Secretary of State's view in this case, in this context. Article 3, no public interest balance. There is a constitutional basis to afford respect to the UNHCR's view. Forget about expertise, forget about the fact they've been there for 30 years with 332 staff, and that this is at the heart of their expertise. They are,
sorry, how many staff?
332, I think.
Yeah.
Present since 1993.
Yeah.
So the current figure of staff is 332.
I think so.
Yes, but you're not saying they were present since 1990.
I shouldn't have got into this. I'll leave it to them. Sorry. Leave it to my learned friends. So forget about expertise. They have the constitutional basis to give their views on these issues. They are the constitutional guardians of the Refugee Convention. See our case 39 and 64, impeccable constitutional mandate, UN General Assembly 1950 statute in 1950, and moreover, state parties, including the UK, have of course agreed to cooperate with the UNHCR in its and facilitate, quote unquote, its duty of supervising the application of the Refugee Convention. That's Article 35. So that's an own goal. And if we are seeing who comes out on top, my Lord Briggs, it's a fairly heavy victory with respect to an own goal for the UNHCR on this issue. The next subject I wanted to look at, if I may, is the past and present, its relevance. It's obvious that in order to determine whether the Rwandan government were capable of delivering on assurances and in what timescale, it was necessary to address the position on the ground and the defects of the system. The Secretary of State's submission is, however, that the historical analysis of the Rwandan asylum system as undertaken by the majority, quote unquote, this is her case 108. In fact, the Lord Chief also shared their concerns and saw them as relevant. She says this was of, quote unquote, limited relevance and should be rejected. We say that submission should be rejected. So should the idea that Israel is irrelevant. Now, first point, if I may, my lords. Again, all three members of the Court of Appeal accepted that the past was relevant. The Lord Chief Justice at 470, the heart of this issue involved an evaluative exercise where past and relevant events inform the evaluation and must be coupled with judgments about good faith. Not that dominates. Intentions to deliver, something on which he said the government does not have special expertise. A capacity of the system to deliver, he didn't mean in terms of volume, and the effect of monitoring. The Master of the Rolls at 91, I don't accept the past and present he was alive to the fact that the evidence was a present system as well. Don't accept that the past and present can either be ignored or sidelined, as the Secretary of State suggests. The likelihood of promises being performed must, in part, be judged by reference to what has happened in the past and capability and capacity. Master Rolls 92, his conclusion that there were risks, Article 3 or treatment, was the consequence of, quote unquote, the historical record described by the UNHCR, significant concerns of the UNHCR, factual realities of the current asylum process in Rwanda. In practice, Rwanda can only deliver on its good faith assurances if it's got control mechanisms and systems in place to enable it to do so. Both the history, current situation demonstrate those mechanisms have not yet been delivered. And then Lord Justice Underhill at 144, what is required is an overview of the totality of the evidence. This is Lord Justice Underhill criticising the Divisional Court at 55. He was unduly generous to them. He said at 144 that they had held it wasn't necessary to resolve. That's how he described it. In fact, they said it wasn't even necessary to address the majority of concerns. And at 149, he said, well, Justice Underhill, that the Division Court had adverted to the quote-unquote airport cases. That's an under-description of them because they show biased decision-making, disregard of refugee convention obligations and so forth, misunderstanding. He said that the Divisional Court had adverted to those cases but had made no findings about what occurred or what conclusions can be drawn from them. The conclusions he drew were at 156, misunderstanding, deliberate disregard, bias decision-making, external foreign relations inspired decision-making. And he said at 270, the court below didn't seek to engage with the details of the UNHCR's criticisms of the RSD process. And then, just coming back to Ottman, a point I've already foreshadowed, our case, paragraph 51, this is what Ottman required them to do, because the obligation to which I've already referred was an obligation on the domestic courts to examine the practical effect of assurances. And then the key phrase is, in light of all prevailing circumstances. And the receiving state's past record, that's one of the factors. It wasn't appropriate or sufficient for the courts to examine how the assurances may, in theory, apply at some point in the future, which is really what Sir James's submissions come down to. He begged the question right at the beginning of his submissions yesterday morning. I was listening very carefully. He said the question, of course Rwanda can deliver, without addressing how, in what time scale, and that I noted the time, it was 11:55 a.m. He came to ability to deliver, didn't deal with it, and went back to volume. Secretary of State's case is very conspicuous in its complete failure to deal with the question of ability. They consistently regard, both in submissions and evidence, the question of capacity to deliver simply in volume terms. It's an incredible lacuna, if we may say so. So going back to Ottman, the court said, even in terms where the assurance there did not concern system change and essentially just concerned an obligation, or sorry, a promise to desist from torturing a high-profile individual, the court said assurances are, quote, not themselves sufficient to ensure adequate protection against the risk of ill treatment. And that passage in Ottman, or those passages in Ottman, were endorsed in Zabolotny, my Lord Lloyd Jones, at paragraph 38 of his judgment for the court. And that's at page 6641. The next point I want to make is a really important one, and it's the point that my Lord Lloyd Jones made very early on in the hearing about no parallel system. The ministerial view on the Rwandan side is this, and the reference is page 3208, paragraph 16 of a statement dated the 2nd of July 2022. This is a statement from the minister on the Rwandan side. She says, it should be stressed that the government of Rwanda will not have a parallel RSD process. She continues, the government of Rwanda has launched an adapted model of the RSD process to best process the expected claims. And the idea being that everyone will benefit. It's not a parallel system, everyone benefits. And similarly, we see that officials lower down the chain, if I can put it like that, had said the process is already in operation. This is not a new process, and this is an exhibit to, I think, Mr. Williams, his statement, and the reference, is page 3201. And the context for that answer is Mr. Williams had suggested, by way of, quote unquote, a soft ask, whether all new non-MEDP asylum seekers could be put through the new MEDP process. And the government's response was, the Rwandans' response was, the process is already in operation. This isn't a new process. And that's also the ministerial view. So with great respect to him, the Lord Chief Justice was wrong at paragraph 502 to say, I mean wrong in the non-technical sense. I can say it in the non-technical sense, because we had a majority. He was wrong at paragraph 502 to say there will no doubt be changes in respect of those considered under the arrangement with the UK. Well, the new system had already been launched in April. Why is this so significant, my lords? The reason it's so significant is because even after the quote-unquote adapted model was quote-unquote launched, poor practices persisted. We see that in two respects. We see that as regards the refoulement cases, and we see that as regards reasons. So firstly, refoulement. In our case, at 61.2, footnotes 87 to 88, we refer to refoulement cases, and the references are, the point I'm going to make is we see that there are, a Syrian individual is removed on the 19th of April, that's 6 days after the MEDP was signed, and the reference there It's Mr. Botnick's third statement, paragraph 14, page 2897, and Exhibit 2 to that statement, page 2920, where he exhibits a formal note verbal on the 21st of April, a week after the publication of the MEDP, referring to removals in March 22 of 2 Afghans and a Syrian individual removed on 19th of April. That was the one, my Lord, the President recalled, chain refooled via Turkey. In fact, the Afghan removals were chain refooled via Dubai, inconsistent with Sir James's suggestion in answer to my Lord yesterday, they don't remove to the Middle East. And the reference there is Mr. Botnick 2, page 2482, paragraphs 108B to C, paragraphs 109 to 111. I'm being told, Mr. Bordell, I gave a wrong reference, 2842.
2842?
Yes, did I say something else? I said 2482. It's 2842, I'm so sorry. 2842. And then also, this is the country X international relations, foreign relations decision making. Mr. Botnick, third statement, paragraph 18, page 2898 to 9, 2898 to 9, and Exhibit 4, page 2927. This is a note verbal of the 31st of May last year, so about 6 weeks after the new adapted system had been launched, in relation to a family who had submitted their asylum application in December 21 to DGIE in the presence of UNHCR staff. I'm reading from 2927. They received a call on the 26th of May, 6 weeks after the MEDP, to go to the DGIE office on the 27th of May for a meeting. During the meeting, they were informed by DGIE they have to leave Rwanda by Wednesday, 1st of June. This is the brave new world of the bespoke MEDP. Refoulement. Reasons. So reasons post-MEDP continue to be absent. And there's a broad reference to this phenomenon in the Master Rolls at paragraph 95. Mr. Botnick, in his third statement, exhibited a refusal letter of the 18th of July of last year. That was a day before our hearing was due to take place. Eventually it was adjourned, but it was a day before the hearing was due to take place. And the reference is 2929. And the reasons given for refusal, it's a refusal letter. Refugee status wasn't granted because you are not meeting the eligibility criteria and the reasons provided during your interview were not pertinent. And lest it be said by Sir James, because I think he made this submission below, that's just a one-off, you've got a nice table in the second statement of Mr. Botnick, page 2826 to 2826 to 2828, we see that letter is an example of the template reasons to which Mr. Botnick referred at paragraph 61D of his statement. And it was provided in 36 of 50 letters the UNHCR had seen in 2022, and he says there was very little more in the other 15. And you'll see the date, numbers, if I could just give you just a very quick reference, 14 decisions dated 18th of May 22, that's numbers 76 to 88. I can't be right. Sorry.
So where are we looking at now?
In his table at 2870, yeah. 2870. And you'll see that, yeah, numbers, thank you, Mr. Waddell, 74, is it? 74, yes, sorry, 75 it should be, 75 to 88, 14 decisions dated 18th of May 2022, 7 of which concern the RSDC session on the 6th of May. Those are numbers 76 to 80, 87 to 88, which postdate the MEDP. And this was an occasion on which Lord Justice Underhill was, it might be said, unduly, not unduly, but generous to the Secretary of State, because he based his conclusions on inadequacy of reasons and the profound need for training to bring the system up to speed without looking at these. But again, this is the brave new world where the past is completely irrelevant. The last document I just want to refer to is the feedback document from the Ministry to UNHCR. That was dated 11th of May 2022. Again, after the MEDP was signed. Pages 3174 to 3175. And that's the document which accuses the UNHCR of deliberately misinterpreting refoulement, the second paragraph. And that's the document, one of the documents that's discussed in the Court of Appeal Master Rolls at 96 to 97, Lord Justice Underhill 146 to 149. But Sir James says that all of this is at best of peripheral relevance, because you can trust us, they'll deliver. The next point I wanted to make concerns Israel and Rwanda. So Sir James's case is this is totally irrelevant. She says the divisional court at paragraph 68 were right. The evidence about what happened is in Mr. Botnick's second statement at para 124 to 125, pages 2847 to 2849. The UNHCR described what happened, intimidation, threats of deportation, as large-scale and gross abuse. That's what they say at paragraph 36 of their observations before this court. It's what they said in the court below. Their evidence was uncontested. The only response that the government of Rwanda gave is at page 3218. Page 3218, you've got a seriatim response to Botnik 2. And what we have on Israel is the government of Rwanda has entered into transfer arrangements for the international protection of refugees that differ from the Rwanda-Israel agreement. They weren't even saying that this arrangement is different. They just said they'd entered into transfer arrangements that differed. Mr. Armstrong dealt with it by saying he couldn't possibly comment because the UK wasn't privy to this. That's paragraph 91, page 2684. Sir James says, as far as one can tell, it's different. The Secretary of State, in her written case, says that it appears in various respects it was different. I'll come on to this in the context of Ilias and the wholesale failure to investigate. What she notably doesn't say is that the abuse didn't occur, nor that it was despite assurances to the contrary. Those would be impossible submissions. Israel would not be consenting to large-scale abuse of non-refoulement in the context of this transfer. And Rwanda's breach of an earlier assurance in this context, even with a state other than the UK, is obviously relevant. See, again, my Lord Jones in Zabolotny at paragraphs 46 to 50, pages 6644 to 6646, our case, paragraph 52. And lest Sir James look at the remainder of that, my Lord will remember, that was a very special, the question of admissibility of evidence was governed by special rules that apply in extradition appeals and so forth. There was no Ilias duty. Ilias was ousted in Zabolotny because of the rule of appeal, not the rule of evidence, as Lord Justice Lords has described it, if your Lordship recalls. But all I need Zabolotny for is for the very obvious proposition that a breach of an earlier assurance with a third state is relevant. How can it possibly not be? Answer, it's not really, we have a bespoke agreement. We have a hermetically sealed sui generis agreement to which ordinary principles of scrutiny just do not apply. That's what it comes down to. As the Court of Appeal said, 152, the evidence goes beyond denial of access to asylum, illustrates arbitrary and oppressive behaviour by Rwandan state agents, presumably the DGIE. That's Lord Justice Underhill at 152. And Master Rolls 101 doesn't agree this was irrelevant. It's illustrative of danger.
What was the last reference? I'm so sorry.
101 to the Master Rolls judgment.
Yeah, thank you.
I don't agree it's irrelevant. what Ms. Botnick described as illustrative of danger. So that's what I want to say about the past and the present, I should say. And then the idea that the MEDP responded to core concerns and built-in concerns about capacity development. And I'll take that together with this idea that it's really significant that we haven't challenged the ex facie coverage of the assurances. It's very obvious why Sir James says that, because he says it's hands-off the courts, hands-off UNHCR on our sui generis hermetically sealed agreement. And if you look at the agreement, it's in theory broad enough to cover all the problems. End of story. That's the structure of his submission. So the idea that this responds to core concerns, he makes that claim at paragraph 88.3. He says the arrangements provide, and in part are intended to provide, a fire break. And that was following careful and active consideration of the core concerns raised by UNHCR. So core concerns in paragraph 88.3. There's some fairly careful drafting here for obvious reasons. In our case, at paragraph 59, at footnote 82, we refer to other formulations in the Secretary of State's case. We have at paragraph 11 that this was in part designed to address concerns with the Rwandan refugee system process that had been identified by the Home Office and so forth, reference to capacity and capability. If you trace through the references, it's very clear that capacity and capability means volume. At paragraph 13, we have, they were designed in part to resolve concerns. At 16, we have, in significant part, designed with some of the concerns in mind. And at 84, that becomes core concerns. And yesterday we had, well, it dealt with the concerns, and then Mr. Botnick provides additional concerns. It's careful drafting. Our case at 59, my lords, the idea that the MEDP was responsive to the UNHCR's core concerns is belied by the evidence. It could not have been, because the Secretary of State didn't know about them, and that is because she had not told the UNHCR of the MEDP before it was published on the 14th of April. And as regards the note verbal, which do a lot of the work, she didn't publish those, and she only disclosed those to the UNHCR after the start of the interim relief hearing on the 10th of June. The reference there, Mr. Botnick describes that, how his solicitors, the UNHCR solicitors, Baker and Kenzie, were chasing through the week, and they eventually get them after the interim relief hearing has commenced. This is the note verbal, which do a lot of the work. And the reference there is page 2853, paragraph 141. That's note verbal. Earlier on in his, just before that, in his statement, Botnick 2, at 130 to 140, pages 2850 to 53, describes the communications and meetings between the UNHCR and the Secretary of State. There was an interview on the 21st of March, but that was, as it were, blind. The UNHCR did not know that this arrangement was in prospect. The notes of that meeting are at page 2624, And it is right to say that some of the concerns were communicated in those notes, in that blind meeting. One eligibility officer, bottleneck at DGIE, no reasons. UNHCR tried to give support, gaps in RSDC, lack of capacity turnover, some may not have the right background training, etc. Legal assistance, the right of legal representation isn't recognised. You can't bring a lawyer before the RSDC. Outcomes, rejection rates are higher for the Middle East and other countries. The view is they should go to neighbouring countries. And they refer to the denial of access of 2 Libyans. So the question that arises is what's missed? Because that's the only meeting they have with the UNHCR before the MEDP. And the answer is really quite a colossal amount. And it's summarised in my Learned French submissions at paragraphs 9, 14.3 and 15, when they talk about the inadequacies of the assurances. But the fundamental thing that's missed, is the extra-legal and opaque role of the DGIE in preparing recommendations, making decisions on security and international relations bases if an individual is quote-unquote unpalatable, their understanding of what refoulement means, the scale of the problem, the in-country history of refoulement under Israel-Rwanda, their propensity to abuse and intimidate. That's missed. All of it's missed. Core concerns are dealt with. This is missed. The lack of lawyers with capacity, never mind what the issues are as regards legal assistance on the one hand and representation. There's a lot of fine evidence about that. But what's completely missed is that you don't have capacity in the system. And these are hardly peripheral matters, as the IAGCI commissioned report confirmed, and the reference there is page 3291, where the reviewer said, I completely appreciate that that may not be agreed with, but it's some evidence of the problems. This is an Asylum Research Centre reviewer. But the reviewer said none of the information provided in the interview notes should be relied upon. The research does not meet even the minimum standards of primary research. And the reviewer highlights that it would have been useful to have evidence, information about the DGIE, the position of the eligibility officer, recognition rates, and so forth. Fundamental gaps of information remain. That's 3292 to 3293. In understated terms, Lord Justice Underhill referred at 268 that it's unfortunate that officials didn't engage with the UNHCR on their first visit to Rwanda in January 22. Their initial intention was to do so. It seems for whatever reason reasons that are unclear. You've seen the references to careful handling. They did not receive the necessary clearance from the Secretary of State. One might add that it was also unfortunate that when they did meet in March, the meeting was blind. The net result is that it is totally impossible, we respectfully submit, not available to Sir James on the evidence to say that the core concerns that emerge in Botnik 2 were taken into account when the MEDP was formulated. The idea of ex facie coverage, our headline submission on that, it's completely irrelevant. completely irrelevant if the assurances meet bias, extra-legal decision-making, the extra-legal role of the DGIE, which is not acknowledged. Historically, it was at one point in the context of Israel, but it's not acknowledged. It's totally irrelevant that if you go by the letter of the assurance, you've got Rwandan law standards. That's problematic for the Secretary of State, given the understanding of refoulement that Rwanda has. It's irrelevant that decisions are to be impartial. It's irrelevant that you've got to have proper reasons. You can't magic away practices and not address how the assurance is going to be implemented in practice. You've seen Ottman. In paragraphs 187 to 189 of Ottman, the court could not have been clearer on the need for a focus on the practical application and the practical effect of assurances. That is hardly surprising, because it's a basic principle, must have been repeated in thousands of cases in Strasbourg, thousands, that human rights, fundamental rights, are to be delivered in a way that's practical and effective rather than theoretical or illusory. Sir James' submission amounts to, never mind the practice, look at the theory. And you have the points about if they don't understand what refoulement is, that's a fundamental obligation, then how is the assurance going to deal with that on the ground? Or the role of the DGIE? I want to move on very quickly to incentives. This is dealt with in our case at paragraph 61. UNHCR deal with it in their case at 19, Secretary of State 83. The idea is that incentives can deliver. This is not something that shows that the Court of Appeal majority were wrong. It's disagreement territory. Lord Chief Justice referred to incentives at paragraph 511. I just want to make 7 very quick points. First point, a prior condition of an incentive is that you understand or accept that there's a problem. And with regard to refoulement, the Rwandans don't. See Master Rolls at 96 to 97, Lord Justice Underhill 146 to 156. And indeed, the Lord Chief Justice refers to these cases, it accepts that they happened, finds them troubling.
Sorry, the reference?
So, the Lord Chief Justice?
At paragraph?
502. Can you just check that? I think that's right. It is 502. So you've got to understand them, you've got to accept there's a problem, and Lord Justice Underhill 169, with regard to interviewing methods, does not accept that. He shows that there's an unacknowledged problem, and that is a problem in terms of rectifying defects by reason of incentive or whatever. Second prior issue is that you've got the capacity to deliver that which is being incentivized. Third point, these aren't just points in the abstract. You've already got the reference to the refoulement cases, and you've got the timeline I gave you. They post-date the MEDP. Some of them date from March 22, just before the MEDP, the month before MEDP was signed. So when it was in prospect, one would think that the Rwandans would have been incentivized then. That's refoulement. Similarly, fourth quick point, reasons. You've got these reasons in May coming out in the way I showed you when the system is already in operation. And again, one would think that there was an incentive to provide proper reasons, as the MOU assures. Yet we had the example I gave you, the day before a division court hearing. The fifth point I wanted to make, despite the incentive to bring the system up to the required level of safety, UNHCR were not aware of any training or remedial programs that would do so. And that's Mr. Botnick's statement at paragraph 144, and that is something I don't have a page for you right now. Mr. Botnick, could you, Mr. Wardell, could you help?
Is that his first statement?
It's a second statement.
Second.
Second statement, 144. Huh? It's 2855. Thank you, Mr. Wardell. And that's responded to. I'm going to deal with training shortly. That's responded to by the government of Rwanda. They make various claims about training. Mr. Botnick, in his third statement, shows that those claims aren't very well founded. I think the position is that UNHCR wanted to give more evidence, and they'll correct me if I'm wrong, wanted to give more evidence to the Divisional Court about the current state, but because of the cut-off, they weren't able to do so. Sir James, in the best traditions of the advocate, gave you some evidence about, or explained that there was further training. It is something that the UNHCR were not able to deal with. So the cut-off really is a cut-off. The sixth point, in terms of incentivization, is, again, Israel. See Exhibit 7 to the second statement of Mr. Botnick, page 2878, where there's a suggestion that part of the deal may have been in return for military aid. It's a suggestion, I don't put any higher than that. But it is unreasonable to think that there would not have been incentives there. The Secretary of State addresses none of these issues as regards funding. The seventh point, I've already made the point that the funding at Rabal was not disclosed to us on the basis that it was irrelevant. And that's our case, paragraph 11, footnote 4. We sought disclosure of it. That was refused by Mr. Justice Swift. Our submission is Ottman 189 sub 1 means you can't properly evaluate the funding incentive. You haven't got the note verbal. I'm not saying that the Secretary of State should have disclosed it. I'm saying she can't rely on it. It's a matter for her that she disclosed it. There may be very good reasons for not to disclose it. She can't then rely on it, our submission. The next topic then I want to deal with is an important one, and that is monitoring. I'm going to spend some time on this, if I may. So we address this at paragraph 70 of our case. It's a long paragraph. The Secretary of State deals with it at paragraphs 90 to 100 of her case, and the UNHCR deal with this at paragraph 17. Again, so James spent some time on it. The Lord Chief Justice obviously did as well, and I will too, if I may. So, we say that the Court of Appeal majority were not wrong in their approach to monitoring, And the Secretary of State doesn't suggest otherwise. All she says is that they gave insufficient weight. It's at paragraph 100. Insufficient weight to the fact that monitoring will cover the entire relocation process from the beginning, and insufficient weight to its capability to pick up any problems and sort them out. That's the Lord Chief Justice at 511. This is disagreement territory. We say, paragraph 70, sub 1, that the Court of Appeal majority took considerable care and did not err as regards this issue. The Master Rolls, paragraph 78, he said this is likely to come too late to affect the risk of these initial asylum seekers facing Article 3 ill treatment. He said it was unclear that these monitoring mechanisms would account sufficiently for the approach to the granting of asylum taken up to now by the Rwandan government. Lord Justice Underhill at 269 cited the Divisional Court at 65, and where they had said, for now at least there's no reason to believe that those bodies won't prove effective. He referred at 271 to that paragraph that it would take time and resources to develop the Rwandan capacity, and he held, Lord Justice Underhill, that the fact that it would take time and resources obviously did not address the immediate term or the short term. As far as the Lord Chief Justice is concerned, his approach to monitoring has got to be seen against the background of what he accepted. And I can say the same for Sir James, because he does not really mount any disagreement with Lord Justice Underhill or the Master Rolls' conclusions on the evidence. He just points to the MOU and the note verbal and various claims about training to say this is how it should work. So the predicate, we say, of the idea that monitoring is an answer is that the system isn't. The Lord Chief Justice accepts at 493 Lord Justice Underhill's analysis. He says that informs this issue. He accepts at 502 UNHCR's concerns about RSDC bias, training, expertise, and he accepts the expertise of the UNHCR and the relevance of the past, and he accepts the troubling features of the refoulement cases. We say, by way of overview, that it is difficult to say that a system as described by Lord Justice Underhill, which plainly gives rise to Article 3 risks, is susceptible to correction by monitoring. The Secretary's reliance on the Lord Chief is unpersuasive, given what he'd accepted. The monitoring system that's envisaged under the MEDP appears to be premised on a functioning system prone to occasional visible error, not one with fundamental defects as to basic competence. Defects as to understanding of key concepts, refoulement. Defects as to capacity in terms of skill and experience in conducting proper processes, as Lord Justice Underhill found. Interviews, hearings, proper presentation of country material, reasons, exacerbated by a refusal to acknowledge that anything is wrong. Lord Justice Underhill at 169. A wholesale lack of training exacerbated by apparently false claims about past provision and current levels. I'll come on to that. The short point is investigated the claim that, in particular, the claim that IOM was providing training was controverted by the IOM themselves. Defects as to capacity of lawyers to exist, bias both at RSDC and DGI level, and opacity as regards to the DGIE's role. Many of these defects raise questions about visibility and transparency, and it's our submission that the majority did not err in thinking that monitoring would come too late and was not a sufficient answer for the scale and nature of the problems in the system. And so we do say that monitoring isn't a protection for individuals if the asylum system isn't, and that is why we suggest Sir James's case travels so much further than the Lord Chief Justice. It has to depend upon extraordinary deference to her views that the MOU will be complied with ignorance of the past and the present, and of the UNHCR's views about the efficacy of the MEDP, relegated on the basis that they know nothing about this.
Can I just interrupt you for a moment, Mr. Hussain? It's just a check on progress. Obviously,
I'm doing better than I thought I would be.
I'm sorry?
I'm doing better than I thought I would be. Your Lordship may not think that.
Well, I was just thinking that I rather inferred that tomorrow was being largely given over to the EU point.
I think the timetable is that I could go till 2:45. I may be quicker than that. I don't know.
Yeah.
But then UNHCR have an hour.
Yeah.
Sir James, can't remember how long he has, but I think he's going to shave some time off because he went a little bit over. Yeah. I've got 15 minutes. Yeah. I finish at 12 o'clock. It's Mr. Drabble from 12 o'clock tomorrow. That's the agreed timetable. Yes. Lord Panic for the Secretary of State.
Yes, you've got a quarter for an hour scheduled for tomorrow. And you're dealing with the...
I'm dealing with grounds 1 to 5. Yeah. Ilias,
yes, I was just thinking you've got a certain amount still to cover.
I do, but as I said...
You're on track.
Yes. In quantitative terms, I'm doing okay. Your Lordships may have a different view about quality.
No comment on that, Mr. Hussain.
No. So, substantive responses to monitoring with that overview. The Lord Chief Justice, paragraph 502, our case at 70.2. The point that I'm just going to make 9 quick points on informal monitoring. Firstly, informal monitoring. So the Lord Chief Justice relied firstly on informal monitoring. But before I get to that, sorry, I should say the first point is paragraph 502 of the Lord Chief Justice. The question that he asked as the question is, we say, not whether the system as a whole can be relied upon, with an implicit suggestion that it is legitimate to balance off bad decisions against generally good ones. I don't say that the system has to be perfect, but the issue isn't whether the system as a whole, with the idea that there's some sort of balancing off. The question, of course, is whether there are substantial grounds for a real risk that the individual won't have access to a safe system. If there's a 65% success rate, it could be said that the system as a whole can be relied upon. That would not be enough. The Lord Chief at 503 says that an important factor is whether monitoring arrangements drive good decision making. That's an incentives argument, You've had my submissions on that already. The starting level, with great respect, is very low. They don't understand refoulement, it's very clear. The evidence is that there's bias. The evidence is that they don't conduct interviews properly, produce country information reports properly. They aren't able to correct these matters overnight. They don't acknowledge that things are wrong and so forth. So informal monitoring is dealt with by the Lord Chief Justice at paragraph 505 of his judgment. It's our case 70.2 and 70.4. Sir James at 97 to 98. The reliance on informal monitoring is speculative and in error. The first point that we make is that the Lord Chief Justice said that shortcomings in interviews, transcripts, interpreters, lawyers, reasons for decision, etc., in accordance with this agreement, would, quote unquote, readily come to light with a good chance of being dealt with. Readily come to light, good chance of being dealt with. First observation, well, what about the good chance that they're not dealt with? The standard is substantial grounds for a real risk. We would also rhetorically ask, what about the shortcomings as to bias or skewed recommendations that are extra-legal that the applicant isn't entitled to see? That's not addressed by the Lord Chief. What about decisions being made for security or political reasons that arise post-consent to transfer and arrival? Compare what the Master Roll said at 104 at the end. He said the problems may come to light, as far as the Rwandans are concerned, after they've consented to transfer. What about decisions, recommendations that are made off the books? That's not addressed by the Lord Chief Justice. What about lack of lawyer capacity? How would that be dealt with via monitoring? How about an unfair interview with points of concern not being put? One would need very close on-the-spot monitoring. Not clear how that could be corrected after the event. And the point is really that this is not like, for example, the Ottman context, where you can have medical monitoring. A doctor can go in every day and examine the individual to see whether they've been tortured. The problems are far more subtle, pervasive, system-wide here. There are issues about visibility. The next point that the Lord Chief Justice made regarding informal monitoring was that the reality, as he referred to it, that anyone removed with their internet-connected mobile phone will be in a strong position to raise concerns with family, friends, lawyers, the High Commission, UNHCR, who pay close attention. And in response, we say, I just want to reiterate, this is disagreement territory, but assume that it's not. I'm going to deal with it on its merits. But our fundamental submission is this is simply disagreement territory. There is colossal and overwhelming evidence of repression for dissent in Rwanda. And that has a chilling effect on the propensity of people to complain. This is our case 70.4.1. And issues concerning mistreatment of asylum seekers in refugee camps when they protested are referred to in decision letters. The point I'm trying to make here is it doesn't really matter whether or not the Kaziba type incident would happen, where refugees would be gunned down or not. That's not the issue. The issue is that has happened, and what impact is that going to have on the propensity of people, and preparedness of people to complain? The reference is in a sample letter in one of my clients' cases, AA, At page 3469, there's a reference to a mistreatment of asylum seekers in refugee camps when they protested. That's in a decision letter. The Kaziba incident is in the Secretary of State's published documents. It's not exactly a secret. The reference is page 2494, para 4.4.3 of the Human Rights CPIN. Human Rights Watch open letter of the 11th of June, page 3178, says, in terms, we are deeply concerned that asylum seekers will be at risk of abuse if they speak up about their treatment or conditions in Rwanda, or could be forced to self-censor. The FCDO acknowledged that if asylum seekers and refugees were not 100% compliant, quote unquote, and subservient to very stringent top-down rules, they would suffer extreme repression. That's at page 3103. The British High Commissioner in Rwanda in February 21 says Rwanda, this is at page 3055A, says Rwanda has a heavy-handed security system, so there's a real risk of refugees falling foul of this if they do not follow the rules. Human Rights Watch describe the intimidation of refugees after the Kaziba incident, page 1658-9. That's an extract from our skeleton argument, paragraph 174 in the Divisional Court. 1658-9, our skeleton 174, where Human Rights Watch described intimidation of refugees post-Kaziba, not to cause trouble or say anything negative about government. In our skeleton, 2 paragraphs down, page 1660, 1660, we referred to senior government of Rwanda officials in 2015 warning refugees not to report attempts to recruit them to fight in military operations. Quite a chilling quote. We have the means to know everything you tell them. Go back to those NGOs and change statements. And then in the context of Israel, those relocated were discouraged to approach Midimar, the predecessor to Minima, the ministry, with threats of non-renewal of documents. And that's Mr. Botnick's second statement, Exhibit 7, page 2889. It's at the top of the page. So overwhelming evidence of repression for dissent and criticism. Chilling effect. Sir James, in his case at paragraph 17, says that others with general or specific interests could report a mobile phone connected to the internet. So assume that we know what they know what to look for. Rwanda, I regret to say, with respect, is a surveillance state. And that's our Divisional Court skeleton, paragraphs 224 to 230, pages 1679 to 80. There is where we cite a former economic advisor to the President saying in July 2021 that the quote, unquote, entire country is a spying machine. And there is colossal evidence of journalists' self-censorship. I'll just give you a couple of references, if I may. So the UNCAT report, the UN Committee Against Torture, page 3050, paragraph 52, it's the second part of the first sentence. The committee remains concerned at consistent reports that political opponents, human rights defenders, and journalists have been increasingly harassed and charged with broadly defined offences for any action or position that is deemed to be in contradiction with the action of the Rwandan authorities. And then DIPTEL, 18th of September 2020, page 3053, para 7. The Constitution provides for freedom of speech, but in practice the fear of arrest or disappearance leads journalists to heavily self-censor. And I'll just give you a couple of references now. Page 3103, this is the FCDO reviewer. And 3105, his bubble. There is no accountability mechanism such as free press. The intel services manage all media houses. No civil society organizations, local human rights organizations. So others, speculative, they would be prepared to intervene. The next point is that it is the DGIE that is to handle complaints. This is our case, paragraph 70.4.4. The pre-departure assurance at page 3270, paragraph 10. The next point is that the UNHCR, I think it's my 7th point, I think I had 9 short points. I think I'm on the 7th one. UNHCR has no observer status. Now, I noticed, with great respect to him, Sir James hesitating slightly when he made the submission yesterday that the UNHCR would, quote unquote, he said, day-to-day monitor or periodically. There's a history to this, which we describe in our case at 70, where the Home Office had initially in decision letters said that the UNHCR would supervise those people who are returned. That was incorrect. It drew an apology, Mr. Gibbs' statement. It's 70.4.2. So we really mustn't come close to that submission that drew an apology to the court and to UNHCR. But the point that I can rest on is that the UNHCR has no observer status in Rwanda. It lacks systemic access, and it is generally not permitted to attend either DGIE interviews or RSD meetings. And my learned friends will I'm sure, give you chapter and verse on that if your lordships desire it. But Mr. Williams, in his Exhibit 6, at page 3200, refers to an exchange where he says at the end of his 3rd paragraph, it is clear, the government of Rwanda, it is clear that they do not want the UNHCR to play a supervisory role. And our case at 70.4.2 and our footnote 100, the Secretary is wrong to say that all notifications of RSD decisions are shared with UNHCR. That's their footnote 21 to their paragraph 91. So that's UNHCR. Hardly day-to-day access. Periodic isn't good enough. The preventative principle is the paradigm, and ex post facto periodic monitoring is good enough. It's obviously the point I'm going to make about the monitoring committee, but that's UNHCR. English lawyers, Secretary of State's paragraph 98, our paragraph 70.4.3, we would rhetorically ask, on what basis? The MEDP is non-binding and non-justiciable. It confers no rights. Page 2367, this is the MOU, page 2367. Commitments do not create or confer any rights on any individual, nor shall compliance be justiciable in any court of law by third parties or individuals, paragraph 2.2. So on what basis are English lawyers supposed to act as an informal monitoring system, we would rhetorically ask. The final point we want to make on this, on informal monitoring, my ninth point, is that individuals are unlikely to know how to identify defects or what compliance looks like. As Lord Justice Underhill said at paragraph 189, typically relocated individuals will have neither the knowledge nor the articulacy to present their case. He made that observation in the context of the problem lawyers not being able to make submissions to the RSDC, but it's obviously pertinent in this context too. Next, the idea of formal monitoring through embedded Home Office officials, Mr. Krellin and Mr. Williams. And it is said by the Lord Chief Justice at 507, they would be able to assess progress, discuss specific issues, flag concerns, including around implementation, to resolve these effectively. And we address this in our case at 70.3.2. UNHCR deal with it at 18.4. Sir James at 92. Again, the broad point I would make is too little, too late. This would be an answer where you've got a functioning system, an essentially functioning system, with minor errors at the margins rather than one with fundamental defects. Quarterly reports, as it put by Mr. Armstrong, quarterly reports, it's periodic basis, not a constant basis, and it's time limited because Rwandans are only required to provide quarterly reports over the first 2 years of the partnership. That's page 3449. Three points here, if I may. Firstly, the liaison officer's function is not a monitoring function. It is, under the MOU, Article 13.4, page 2371, 13.4, 2371, it is to facilitate coordination under this arrangement. And neither Mr. Krellin nor Mr. Williams describe their role as involving any sort of formal monitoring. Mr. Krellin, paragraphs 5 to 6, page 2735 to 6. Mr. Krellin 2, second statement, paragraph 5. Just give me the paragraph for that, the page number for that. And Mr. Williams, I'll give you the paragraph, Krellin 2, paragraph 5. Mr. Williams, paragraph 4, page 2707. And the Krellin 2 is 2735. Thank you, Mr. Wardell.
2735. 2735 was a reference to Krellin 1.
Ah, you're right.
Paragraphs 5 to 6.
Yeah, no, I wanted Krellin 2.
Can't be the same.
Krellin 2, paragraph 5. You want to get it? 2757. 2757, thank you.
2757, thank you.
Sorry, my lord, thank you. The second point I would make, so the first point is they don't describe that, that's not their function. Second point, look at the track record. Unsurprisingly, it's not great as far as monitoring is concerned, because despite the access provided by the MOU in 13.5, and despite their presence in Rwanda since February of this year, and despite their engagement with the process, neither Mr. Krellin nor Mr. Williams explain how they sought to investigate concerns, including around implementation, of a system that had been launched after the MEDP, including by observing any stage of the process. See the examples I gave about refoulement. See the example I gave about poor reasons. They don't address that. They're giving evidence for the purposes of these proceedings. They don't explain how they addressed that when they were negotiating, the UK was negotiating the MEDP. They don't address any of this when they were assessing the readiness for the 14th of June flight, which was specifically mentioned by Mr. Krellin at paragraph 6, page 2736, sorry. Another example, in terms of this idea of formal monitoring through the embedded liaison officers.
Can I just ask, are any of these monitoring reports to be published?
I
don't want to be unduly cynical, but if the Home Office got word that there were problems, what then? Does it suspend the agreement?
I think it's pretty clear that there's no provision for that in the MOU. The monitoring committee itself, we haven't even got onto that. We haven't got onto the dedicated body that's supposed to be doing the work. We're still on the dedicated body that's doing the work, the supposedly independent committee with distinguished English barristers, has no teeth. Its recommendations aren't binding. We'll see in a moment how it reports to the joint committee on which sit, inter alia, the DGIE. So the entire system, really, of monitoring, as I've said before, I hope, forgive me for repeating, it is really high level, lacks teeth, lacks efficacy. It's really designed to overlook a system that is essentially functioning with marginal errors, rather than something that is as defective as Lord Justice Underhill found it to be. And hence my submission that if the system can't deliver safety, then monitoring certainly cannot. And Mr. Bordell, again, very grateful to him as ever, page 3449, it's the report once a year, summary only for publication. And no automaticity as to suspension, I'm pretty sure. That's the MOU, it's not as if that brings it down. The reference I was going to give...
Sorry, the reference you just gave us, I noted it as 3349, but I wonder if...
3449, again, I've got it wrong.
No, sorry, my fault, 3449, thank you.
That's the terms of reference of the monitoring committee.
Yes.
3449.
Yes, so it would, the summary report would be for publication.
Thank you.
The summary only. The reference I was going to give you as another example of the inefficacy of this idea of formal monitoring through embedded liaison officers is in the asylum system CPIN at paragraph 5.4.4, page 2429.
No, not 5.4.4. You mean 4.5.4?
It's 4.5.5. I'm really sorry. Don't know if it's age modelled. It is. 4.5.4. Sorry, I keep getting it wrong. Yes. So in a meeting between the Home Office and the Government of Rwanda on 22nd of March 2022, minimum officer showed the Home Office team examples of documents taken from case files and stated they were various things. Due to privacy concerns, timing, language barriers, and the scope of experience of the minimum official, the Home Office team were unable to obtain further detail from the source on the substance of their documents. This is the Home Office's CPIN. So it looks as though they weren't able to even review this material in a language they understood. And that's something that's picked up upon by the ARC reviewer for the IAGCI at page 3400, paragraph 116. Page 3400, paragraph 116, where the reviewer says, quote, given the importance of fully understanding the Rwandan asylum system, it is extremely surprising and worrying that resources weren't provided to the Home Office officials to translate these documents and ensure confidential information was redacted before viewing. And the third example is that the Secretary of State has been, is the uncritical, too ready acceptance of information given to Home Office officials by the Rwandans as regard readiness for transfer. See Mr. Williams, para 44, just give you one example. Para 44, pages 2716 to 7. So para 44, 2716 to 7. Various claims made by the DGI as regards training, including by the IOM. IOM has, quote, from them, never provided nor is planning to provide such training. Mr. Botnick 3 exhibits a letter from them, Exhibit 6, page 2931. And this was one of a series of very questionable claims about training, which we outlined in our note below at page 2351. Mr. Botnick says training and hiring of Rwandan officials, lawyers, interpreters did not begin in this period. Mr. Botnick 2, para 144, page 2855, Court of Appeal below, Lord Justice Underhill 257 to 260, Master Rolls agreed at 99, accepted that. And the last point I was going to make is that, of course, we intend no criticism whatsoever of Mr. Krellin or Mr. Williams. They have a facilitation role. They don't have an oversight role, let alone a monitoring role, and that perhaps explains what's happened. If that's a convenient moment, I don't have that much more to do on the Monitoring Committee or the Joint Committee, and then I have a few shorter topics to cover before I get to Ilias.
Very well. We'll resume at 2 o'clock.
Thank you very much.